Session, Sasser presiding.
All right, good morning, everyone. We're also covering for Judge Curley today to help him out. So it's nice to see everyone. We're going to take our cases and Judge Curley's cases as well. So let me go ahead and get started. We have a telephonic one. All right. Do we have a team ready to go on Webster versus Abraham? Webster, Abraham, is there a team? Are both sides here?
No, that's the telephonic.
Nobody's here. Yeah, I don't know. It's okay. Oh, is it? Oh, April. That's our 8:30. Okay, let me give them a call then for the 8:30.
Welcome. This service is provided by freeconferencecall.com. Please enter your access code followed by the pound or hash sign. You entered 644885. If this is correct, press 1. You are the only participant in the conference.
No hearing them, Michelle. Just tell them they're not available. So that's the we called it and they're not available. All right, Lakeview Loans versus Sonson, please. We have a team ready at Lakeview Loans versus Sonson. No, okay. Hockenberry versus Torek. We have a team ready.
I'm here.
Both sides aren't here yet. Okay, no problem. We'll just wait. Fisher versus Debricant.
Waiting for opposing counsel.
Okay, no problem. Wells Fargo Bank Cone. Okay. All right, no problem then. Deutsche Bank Pierre Lewis. Okay, I guess we're just waiting for opposing counsel. Not a problem. I know there's a long line downstairs, so I completely understand. Yes. Yeah, because they weren't there. It's due today at 8:45, Michelle. It's not a special sit hearing. If we have any teams ready, let me know, everyone. Do you have any teams ready to go? Not yet? Okay.
Anyone on black?
Come on. All right, we got a team. Okay, that's fine. Come on, we'll take one team at a time then. Good morning.
Good morning.
Hi, guys. All right,
We're
come
on
on.
the CMC, Wilmington versus Home.
Hold on a second. Let me get my CMC list. Okay. I'm sorry. Which one is this?
Wilmington,
Wilmington versus Holler?
Oh,
Yes. Oh, Cohen. Okay. Wilmington. Michelle, can you hear this? Michelle's got to listen to CMCs. All right. Wilmington versus Hone. Yeah, that's 2018-15255, number 15. What's the status?
the defendant just filed an answer yesterday. There's some discovery outstanding, and we filed a motion to extend, so if we can get another CMC in 60 days.
Motion to extend what?
Time to respond to discovery.
That's granted. You have 5 days. No CMC within 60 days. CMC within, so that'll close it. So motion is granted. Okay, 10 additional days to respond.
10 days?
10 days.
CMC within how many days?
CMC within, we'll do CMC within 45 days. Okay. All right, thank you guys.
And then I have one other CMC, I don't know if they'll take it.
Sure, as long as we have a team ready.
It's, the other side's not here, but it's US Bank versus Gannon.
Okay, what number is it?
She didn't tell me the number.
Okay, US Gannon, that's fine. 31. What's the status?
Plaintiff's response to defendant's first request for production hearing is scheduled for tomorrow
Okay,
on your UMC, and we have an MSJ hearing set for March 6th.
perfect. So we'll do a, that's fine then. So we do not need to do a CMC on that since the MSJ is already set. So that's Gannon. Okay, got it?
So I don't need an order on that,
You don't need
Judge?
an order on that one.
Thank you.
All right, thank you.
Your Honor?
Yes.
Number 7 is dismissed.
Okay,
It
that's-
should not be in the docket.
Okay, so we will close it then. So it's not, it's currently open. So we're gonna go ahead and dismiss it then. That's a 2012 case. Michelle, let's close that one out. All right, good morning, guys. Vacation hearing.
Good morning. Bank United versus Black, Your Honor. I'm here for that, Your
Hold
Honor.
on, let me just find it on my list. Here it is.
Number 11.
Number 11, wonderful. What's the status of that case, guys?
Your Honor, Adam Schwartz, we're at issue. We're here for the plaintiff, we're at issue. I filed my notice of trial readiness. We have a motion to substitute party plaintiff scheduled for March 5th, and we're ready for a trial setting. order.
Wonderful. Do you guys want to go ahead and you need to give you a trial date then?
Yes, please.
Yeah, I would just request it just further out rather than sooner, because we do have that motion for substitute.
It's a de
coming up.
minimis motion, 30, 45 days.
Yeah, can we go ahead and schedule it out for you guys in 30, 45 days? Is that okay?
That's fine,
Okay.
Justice
How much
Schreiber.
time do you need for the trial?
2 hours, because it's going to be contested.
Not a problem then. Two-hour trial, Michelle, 45 days. U.S. Bank United versus Black. You'll get a trial order by email today.
Thank you.
Thank you, Your Honor.
Thank you, guys. And if you want to do an agreed order and substitution, that's fine. Otherwise, we'll do it at UMC.
I tried to, but we
No, Mr. Act is going to be opposing that.
On motion to substitute, okay, not a
I tried
problem.
to tell them otherwise.
Okay. We'll see you guys in March.
you,
Not a
ma'am.
problem. Thank you, guys. All right, what case you guys here on?
Your Honor, Carrie Sable, Fannie Mae versus Winnie.
Okay, let me just find it on my list. Hold on just a second.
It's actually Judge Curley.
Oh, Judge Curley's case.
on
Oh, yes, okay.
I gave the
Yeah,
paperwork.
Fannie Mae, Michelle. Fannie Mae versus Wayne, yeah, and this is a motion for entry of the writ, which
Yes,
I
Your Honor.
have here. Is there any opposition to the writ?
Daniel Brinley on behalf of the defendant. We've reached an agreement of March 1st.
Great, is that here March 1st?
It is, Your
Okay,
Honor.
I'll put that order in there.
Space on the order.
Not a problem, so Michelle, the writ will issue March 1st, and we'll sign it for you.
Thank you, Your Honor.
Thank you guys for being up. Have a great day.
Yeah, I have a second one as well.
Sure, what's the next case?
Lakeview Loan versus Sonson,
Sunset, okay, let me find that on my list, hold on just a second.
and that's on your docket.
Yeah, I'm just looking for that on my list. I don't think that's not CMC, that's UMC, right?
UMC, yes.
Okay,
Judge.
great, what's the status of that one?
Well, we're seeking a writ of possession as well. I represent the third-party purchaser. There's a certificate of title attached to the motion, which was issued on February 1st. There's a copy of the tenant notice as Exhibit B, which also was delivered February 1st, and we're seeking writ of possession. There is opposition.
Okay, what's the basis of the opposition?
Good morning, Your Honor. Two-part opposition. Number one, the notice was not sent pursuant to the Protecting Tenants in Foreclosure Act, which Congress and the executive signed.
So who didn't get notice? Can you tell me?
No, the notice is sufficient because it's supposed to be under the federal act and not the state act. And so the state act gives them 30 days, but a permanent extension of the Protecting Tenants in Foreclosure Act was signed into law in May of last year.
I'm fine, I'm happy to go ahead and serve them an additional copy of a notice today to you, and that way you can send it to your client to represent the tenant?
Yes, Your Honor.
Okay, that's fine then, council, just go ahead and send her a notice today, and that's fine then, and then we'll go ahead, but we'll issue the writ 45 days out.
That's fine, Your Honor.
Well, hang on, Your Honor, because we do have a response to that. We consider the lease a sham to begin with, for a number of reasons.
Okay.
One is, it's not even a lease to begin with. It's a contractual lease, which is an agreement to agree in the future, which is no agreement at all. Secondly is, we believe there is a relationship between the prior owner and the alleged tenant.
Okay.
But most importantly, the amount is significantly, substantially below fair market value, which is an important issue
Okay.
to determine whether it's a valid lease. My client paid $231,500 for the house.
Okay.
The lease is for $1,000 per month, and the lease was entered, I think, less than a month prior to the sale. I don't remember the exact sale date. The
Is
lease
there a
was
relationship between the tenant and the lessor?
So the act says that it's parent, spouse, child. That's not the relationship that we have here. It's a distant uncle. And he has been paying not just, so the base rent is $1,000, right? But on top of that, he was supposed to pay, which is current, the HOA fees, all the landscaping fees, plus utilities, etc. So it comes to like $1,600-1,700. In
What about
addition-
council's first position that it's not a lease, it's just an agreement to enter
No.
into a lease?
Yeah, okay, so it is a lease, Your Honor. It is a lease. We can show counsel, this is not an evidentiary hearing today, but we can show counsel, and we can put forth testimony of the realtor, of the payments, we can make, show proof of the payments that have been made pursuant to the contract, and, the argument that, well, you know, it was just $1,000, again, that's not the total amount, considering the HOA fees, but also we have to take into consideration that the property was under foreclosure. And so nobody is going to pay, above fair market value or even fair market value for a property that, could be lost in foreclosure. And so all we're asking is let's comply with the act.
Okay, why not give her 45 days at this point in time? Just because otherwise I'll have to do an evidentiary hearing to determine the relationship. She's saying it's not a parent-child, husband-spouse relationship. Because otherwise I don't know whose word to take for it.
Correct. Well, she's acknowledged it's a relative. She's acknowledged that the tenants were aware it was in foreclosure. She's acknowledged it's below fair market value. The lease was like 15 days before the sale.
It wasn't 15 days.
The sale was January 16th. The lease was signed December 29th. However, it's not a lease, but
What's the first day we
Can
can
I-
do this if you give the 30 days notice?
let me take a minute to talk to her and see if we can make an arrangement for the 45 days. I'll call my client.
Why don't we do that?
Because there's a reason that they don't want to give time. There were some threats made.
Your Honor, my clients don't speak English, okay? And they were not represented. So in their mind, if they put an AC unit, which they did, it was part of the agreement to the reduced amount because there was no AC
Why don't you
unit.
guys see if you can work it out, otherwise I'm gonna give
Sure.
45 days, Michelle, you there. 45 days, okay. All right, what case you guys have?
We've got a case management conference, Wells versus Hurwich, 2018-9524.
Let me just find it, Wells versus Hurwich, hold on a second, let me just find it on what it is.
Well, I do understand that.
Here it is, number 37, what's the status of this one?
It's not an issue. The only thing outstanding is a motion to default unknown party in possession number 1. With that
Is that
default
separate?
enter, it'll put that.
Okay, all right, any objection to default?
No, Your Honor, Mr. Wilson for the defendant, and that's not the plan.
Okay, I'm gonna go ahead and grant the order of default, we'll go ahead and take care of that then. So the pleadings will be an issue then, and then what we can do is we can do another CMC 45 days. Once the pleadings are issued, then we'll get you guys to call it.
All right,
All right, thank you guys, have a great day.
Thank
That's
you.
number 37.
Judge, I've got one more.
Sure, what's the next case?
Bank of New York Mellon versus Peterman, 2018-14150.
That's number 18, yes, what's the status of that one?
That one is not an issue. There was just a motion for extension of time that was granted on February 8th. They have 30 days to file a response. So if we can get another CMC.
30 days to file a response. I granted 30 days to file a response, I doubt that. An agreed order, I would never do 30 days to file, oh, well, that's fine, 30 days to file a response, that's, okay, 30 days it is then, that's fine. Okay, all right, 30 days to file a response, we'll do another CMC, let's say 60 days on that one.
Great.
Okay, thank you guys.
Thank you very
All
much.
right, what case you hearing, Counselor?
AV versus Ali.
Let me find it, then, hold on just a second. Baby Ali, and that is, not Baby Walk, I think Baby Walk on this one. Here it is, oh, yeah, number 2. What's the status of this one?
So the borrower is currently on a stiff to mod. They have 2 payments left, February 21st and March 21st.
Great.
And so obviously it'll
Yeah.
convert, so we
Yeah.
can set another CMC.
Yeah, let me do 90-day CMC on that one, they're making the payments, Michelle.
Thank you.
Wonderful, thank you so much, have a great day. All right, next case, what case you hearing?
Yes, good morning, Your Honor. Stroh for Sandell Fireworks, Court.
Is that a UMC or a CMC?
That's the
That's a
UMC.
UMC, let me find it, hold on a second. That's fine, what's the motion, Counsel?
This is my motion, Your Honor. I represent the Department of Financial Services, multiple defendants. It's our motion to dismiss with prejudice. I don't know if Your Honor received.
I did, I just don't have an extra copy, but that's fine.
Would you like an extra copy?
No, I read it before.
Your Honor, if you've read before, I'm not going to bore you with the details. The biggest issue here is this complaint is called scattershot would be way underselling it. I've got 3 defendants, 2 defendants now, maybe. The problem being the defendant's name in the caption, in the civil cover sheet, not the same defendants that were named in the complaint.
Yeah, it needs
I've
to
got,
match up.
I know, I've got the Department of Financial Services, I don't think they were actually ever named an accountant. I've got the Department of Financial Services Chief Financial Officer. That entity has been ignored for some reason, I don't know, that's really, so basically what's going on is there are implied warranty claims that can't stand against the state. There are no facts.
Let's do one thing at a time then. How can we sue the state for implied warranty?
Will, Your Honor, at this point here for the implied warranty, you have to see what the facts are.
You can't sue the state court. You can't sue the state of Florida for implied warranty.
Okay, even,
What's the legal basis? Is there a legal basis?
the legal basis, Your Honor, is that they have to be a native party in the suit.
But they're not, then you can't sue them for that cause of action. I think counsel's right, I think you want to clean up this complaint. The caption doesn't even match up in the civil cover sheet, the pleadings. Do you want time to clean this up?
Yeah, we do, Your Honor. We're scheduled on April the 1st. Why don't we come back?
What do you have scheduled on April the 1st?
The other defendant's motions to dismiss.
Okay, I'm gonna dismiss everything. I'm gonna dismiss everything. I'm gonna want you to do an amended complaint. Let's go ahead and read the allegations and the other defendant's motions to dismiss and counsel's motion to dismiss, and let's amend. How much time do you need to amend?
60 days?
60 days to amend. Okay, that's an awful long time. We're not-
45, Your Honor, maybe?
45 days.
I was hoping for 10. I've been for 2 months trying to get this heard.
Yeah, that's an awful long time. I'm gonna go ahead and give you 20 days to amend, okay?
Okay.
You need to move the case forward.
All right.
So 20 days to amend, but all the motions to dismiss are granted without prejudice. 20 days to amend. Let's clean up the allegations. Let's make sure that the civil cover sheet matches the allegations in the complaint with the right parties. Let's make sure we don't sue the state for claims that the state of Florida cannot be sued for. Okay, 20 days to amend.
Is there a substantive finding that the implied warranty claims are dismissed
Yes.
with prejudice, or is that more?
Are you gonna refile the implied warranty claims, or, I don't know legally how you can word those.
I'm not sure, Your Honor, I'll be honest with you. I'm here on behalf of, the named attorney in the case, whether he wants to do that or not.
Let me just put without prejudice, and hopefully they won't bring it again.
I think it would be helpful if we required that Mr. Fay appear for the actual hearing when we get
Yeah,
back.
let's put that in the order. When it's reset, let's have Mr. Fay appear. Okay, not coverage.
Thank you very much, Your Honor.
All the motions are granted. If you guys can just email me the orders to me.
Sure, sounds
Thank you
good.
guys. Leave
Thank you.
those off in April now.
Okay.
Thank you guys. Have a great day, everyone.
You too.
Have a great day, council. All right. Hey, you're on morning, guys. Location you're in.
We're here on Fisher versus DeBrincat. I don't believe you have a copy of the motion.
No, I don't. Yeah, that's fine.
Judge Curley.
Yeah, this one I don't have to Judge Curley. Thank you guys so much. All right, we're going to see what this is.
I don't think you're going to be able to do it.
Okay, this is a request to have a motion for summary judgment heard at the beginning of the final hearing. Are you having some difficulty scheduling some?
Yes, we have a tremendous amount of difficulty scheduling. Judge Curley's, we were looking for half an hour, we kept on hitting the system, and kept on saying that there was no time available. Then, when we finally did get a point where there was time available, it looked like it was going to be past the time we were going to have.
Oh, okay.
I don't know.
Okay, all right, what are your response?
Motion was filed in April. I think Mr. Taylor waited a while before he tried to set it for hearing. It's a 2009 case.
I saw that.
It's an issue that could have been brought up in the first month of litigation, whether there was a bona fide termination of the, which is one of the elements of the malicious prosecution. You can bring it up on direct verdict perhaps, but I don't think it's appropriate to set it.
When is your final hearing?
We don't know yet. We were sure that it was going to be the first week of March.
Last week of February.
Okay, yeah, he's still in his tobacco trial, and I'm trying to help him out. So here's what I'll do. I'm going to go down and talk to his judicial assistant, Lucille, and I will make sure. I think on Friday he won't be at trial, so he should be able to hear the MSJ on Friday then, and then hopefully he'll be able to hear your final hearing next week then, and March is
So
scheduled.
the MSJ will be on Friday?
That's what I'm going to make sure. How much time do you need for the MSJ?
30 minutes.
Is that okay? 30 minutes
That's
on Friday?
fine.
That way at least we'll get it done, and that way you guys can do
Thank
your
you.
final hearing next week, and that way the case can move. It's a
Thank you.
2009 case, it needs to be taken care of. All right, Michelle, let's hold on to that for Lucille. Thank you guys, have a great day. All right, guys, what case you hearing?
Good morning, Your Honor. Stephen White on behalf of plaintiff, Bank of America v. Sierra, 2018 CA 3507.
Okay, let me find that one. Hold on just a second. Sierra. Okay, yeah, yes it is. Number 16, Michelle. What's the status of that one?
We have a pending motion to substitute party plaintiff. Council's agreed to entry of an order to substitute the plaintiff, and I think we're otherwise at issue.
Wonderful. How much time do you need for the trial? I'll give you guys a trial date.
Your Honor, I'm just asked time. The problem is my clients have been negotiating with Bank of America, and they've been waiting for a response from them, and the response was they don't own it. It took a while. Can we do?
It did get transferred.
That's fine. So have you guys mediated to see if you can resolve the case?
Would you like
Would you want to mediate?
Sure, Your Honor.
Okay, let's do this. Let's do mediation within 30 days, trial within 60 days.
Can we do mediation with a 45, just a 40?
Mediation within 45 days, trial within 90 days.
90, 45.
Let's do that. Does that work? Mediation
We'll have to
45
make it
days.
work.
Yeah, we'll try to make it work and then mediation, trial 45 days, trial 90 days. Thank you guys. That's number 16.
Thank you, Your Honor.
Have a great day, guys. All right. What case you have?
Good morning, Your Honor. Dan Biazek for the defendant.
Yes.
Good morning, Your Honor. Julio Bernardi on behalf of the plaintiff. 2015 CA 008027. Foreclosed assets versus Salmon.
I'm sorry, Sanders, you said?
Yeah, 2015-8027.
It's number 8, okay, yes. What's the status of this one?
Yes, Your Honor, this is the case where the last decision came down reversing to stop the trial. We're still waiting the Supreme Court to reverse the issue for this case.
But there was actually a motion for rehearing filed, so they actually, so who knows what's going to happen on that one?
We don't
That's up in the air.
So we would ask for a 60-day CMC reset.
Yeah, that's fine. 60 days reset. Number 8, Michelle, 60-day reset.
Thank you, Your Honor.
Thank you, guys. Have a great day. All right. Good morning. What case you got?
Good morning, Your Honor. I'm here on U.S. Bank versus Walter Scott Jackson.
Yeah, that's number 12. What's the status of this one?
Your Honor, this case is at issue. We're getting ready to prepare our motion for summary judgment.
Wonderful. I'll give you a trial date. How much time do you need for the trial?
Hour would be fine. An hour.
Okay, 1 hour trial. Michelle, within 45 minutes.
Do you need to prepare an
That's
order,
number 12.
or we'll just get the trial order?
Michelle's going to email you the trial order. 45 days for the trial. Thank you so much.
Thank you.
1 hour.
I have one of two
Sure.
orders.
What's the next case?
Wilmington Trust Company versus Joyce Taylor.
Taylor, let me find that one. Just a second. Here it is, number 6. What's the status?
Your Honor, we just submitted the default on 2 defendants, and we're in the process of pubbing on the unknown heirs of Ms. Taylor. So we're still working through
Okay, that's a
the
2015 case. So that one we're going to need to move forward. So that one I'm going to do a 30-day CMC. Okay. And number 6, Michelle, 30 days CMC.
And you're going to send the order on that one?
We'll send the order.
What's the next one? The next one, Your Honor, is JP Morgan Chase versus Joel Chavez.
Let me find that one. Hold on just a second. Oh, Chavez. Number 9. Okay, what's the status on that one?
Your Honor, only one defendant responded. We, Mr. Chavez, in a loan modification review with our office. So we, with the plaintiff, so we would like to continue the CMC.
That's fine. So on that one, since he's below modification review, we'll do 90 days CMC on that one.
90 days CMC.
Okay. Yep.
I don't know if she heard you.
That's okay. I'll put it. I made notes on it. That's fine.
Thank you.
Okay, thank you so much. Have a great day. All right. Good morning. Location here?
Deutsche Bank, Jennifer Osorio.
Osorio. Hold on just a second.
It's
Osorio, you said? Oh, yeah. What's the status of that one?
On that one, the defendants have until February 25th to respond according to an order under motion for extension time, so the case is not an issue.
Okay, that's fine then. So on that one, we'll go ahead and do a 60-day CMC.
And then,
All right, thank you so much.
Thank you, Your Honor.
Thank you, Your Honor.
we have also, I have CIT Bank via non-heirs, Gloria Liebert.
Okay, yep, here, that's number 23. What's the status of that one?
This one's at issue. There's a trial already set for the 21st.
March?
Of this.
February? Okay, we'll leave it as is. That's perfect. Thank you so much.
And we have also reverse mortgage via non-heirs of Mary F. Buckley.
Yeah, that's number 34. What's the status of that one?
This one's at issue, and we can get a trial date.
Trial date, how much time for the trial?
15 minutes.
Oh, you can, let's set that for trial within 45 days at UMC.
Okay.
So that one, just do an order, set it for trial 45 days at UMC, and you set that for trial.
Okay.
You set that for trial yourself, okay? Actually, Michelle can do that. Michelle, just set that for trial, 45 days at UMC.
Okay.
That's number 34. You have a great day.
I have a couple more.
Sure, what's your next one?
Wells Fargo v. Susan Investment. And this one we are
29. Okay, what's the status of that one?
This one is being reviewed for loan modification. If we can get a 90 days.
90 days CMC on that one. Okay, got it.
And the last one is Bank of New York with David Roy.
Roy, okay.
Roy, R-O-Y.
You find that one. Here it is, that's 24. What's the status of that one? Roy, yes.
Okay. On that one, there was an issue with the default. We set a motion for judicial default against David Roy.
Okay.
Because Amanda Roy filed an attorney for Amanda Roy filed an notice of appearance and we give a motion for extension.
Do you represent the defendant?
I represent both, Your Honor.
Okay, so that's what we did, and that's what was going on. And what you filed was only for Amanda, so default for David wasn't entered because it said that no.
Well, you said dead counsel anyway, so we don't need to call.
Notice appearance was said and family, and then somehow the word family dropped
No
off.
problem. So why don't we do this? Have you called an answer to the complaint?
On the motion for extension, Your
Okay,
Honor.
motion for extension is granted. How much time do you need?
20 days would be great.
20 days, okay. Let's do that in order right now. Motion for extension time is granted. 20 days to file an answer to the complaint.
Great.
All right, thank you guys. Have a great day. And on that one, we will do a 90-day CMC.
Okay.
Yeah, on Roy, 24.
I'll prepare the order.
Okay, perfect, thank you so much.
Thank you.
All right, good morning, guys, what case you got?
We're here on Bank of America versus Esmeralda Perez, Your Honor.
Okay, let me find it, hold on just a second. Okay, that's number 38. What's the status of that?
Okay, there's actually a pending motion for judicial default against the unknown tenant, which we've cross-noticed for today.
That's fine, that's great.
That's granted, and we would ask that CMC be reset even though the case is technically at issue. We believe that we could potentially resolve the case, and we're also
Do you want
preparing a
formal
summary
mediation,
judgment.
or would that be helpful?
I don't think it would at this time, but we will continue to work
Okay,
together.
that's fine then. So let's do a 60-day CMC on that one.
60 days.
Okay, hopefully you guys can settle the case, that would be great.
Okay.
Thank you guys, have a great day. Thank you, Your Honor.
Your Honor, I actually have two more.
Sure, yeah, what's the next one?
There may be an opposing counsel.
I'll call it out, which one?
That one is, hold on one second. The one with the opposing counsel is HSBC versus David Kendall.
Kendall, okay, let me find it, hold on just a second. Number 25, okay. Anybody here on HSBC versus Kendall? Oh, there we go. All right, good morning, all right. And what is the status of this case, guys?
Well, Your Honor, technically the case is at issue, but I believe opposing counsel recently filed a motion to compel better answers to discovery.
Well, that has nothing to do with the case not being an issue. All right, you can set that discovery motion if you want to see anything you want. How much time do you need for the trial?
I would imagine an hour would be
Okay, we'll
sufficient.
set you guys for trial in an hour within,
An hour won't work, Your Honor.
how much time?
I would say at least 3 hours.
That's fine, 3 hours, we'll set you guys for trial within 90 days. Thank you guys, have a great day.
And I have one more, Your Honor,
Sure, what's next one?
which is completely uncontested.
Which one?
It is Wilmington versus Icario Romero.
Yeah, that's number 39. What's the status of that one?
This one is technically an issue, but we have a AOI that's about to be received from the client, so we would ask that CMC be reset in 90 days.
That's fine.
Because we can probably resolve this.
Oh, right, okay. 90 days CMC on that one, number 39. All right, thank you so much. Have a great day. All right, good morning. What case you guys here on?
Good morning, Judge. Centennial Bank versus Alfonso Scott.
Okay, let me find it on my list. Here we go, that's number 19. What's the status of this one?
Case is at issue. We complied with discovery. I worked at the plant. I think we're planning on filing a motion for summary judgment in the next 30 days. It's a 2018 case.
Not a problem. You can do that on the trial date as well. How much time do you need for the trial?
An hour.
Hour? Okay, we'll set you guys for trial within 90 days. You can do your MSJ before then.
Okay.
Okay,
Do
perfect.
we need to set anything on the order?
Just put there, the MSJ will be filed and set within 45 days, trial within 90 days.
Okay.
Thank you guys, have a good day.
Thank you.
All right. Good morning. Okay, Sharon?
Morning, Your Honor. I'm here on UMC for Judge Curley.
Sure, what case?
It's Meta versus Beach Life Development.
Sure, let me just find the paperwork here just a second. What's the motion?
It's a motion for default judgment as to one party, and then I've got a stipulated consent with all other parties.
That's fine. So let me go ahead and grant the default as to the one party that says to count one, and I'll grant your stipulation as to the other parties.
All right, may I approach, Your
Yeah,
Honor?
just hand that to the bailiff, and I'll take the paperwork. That would be good. Have a great day. All right, you guys ready? What case you have?
We're here on Garofalo versus Sapodeo.
That's your turn, or is that one?
No, that's yours.
Okay, that's
You
yours.
want to teach
Okay, okay, I have it.
You'll get these.
All right, you may proceed with the
You
ready.
need the paperwork, I can give it to you.
No, I have yours.
Yeah, Your Honor, this is a personal injury case that arises out of an attack of a donkey on my client's horses. There's discovery that was filed originally with the complaint served, attached the service to the motion. There was no response. We waited until after the holidays as a professional courtesy. We still have received no responses. I filed per the local rules, the ex parte.
Did you get the ex parte order back yet?
I did.
Okay, great.
It's in violation at this
Yeah.
point in time, so we're basically without interrogatories for request for production.
You're entitled to it. Yeah, let me hear the response.
Yes, Your Honor. Maybe you could tell by the names of my clients.
They need to respond to discovery.
They don't understand English law very well.
I understand,
And I
but they
have
have-
trouble with it.
But you gotta get maybe a translator, or maybe help them understand they have to respond to discovery?
I think I've finally gotten through to them.
Okay.
And I do have the
interrogatories,
Okay, and are they ready now?
and I can get the request for productions.
Okay, I'm going to grant, I'm not asking too much time then. 3 days to respond to the interrogatories request for production. If failure to respond, I'm going to hit them, they're going to have to pay attorney's fees and costs. Okay, so 3 days, the motion's granted. So one copy of the order, keep your envelope. Motion's granted 3 days for both the interrogatories and request for production. Otherwise, council's going to be entitled to attorney's fees and costs.
Thank you.
All right, thank you. Bridget? All right, good morning. What case you
Good
got?
morning, Your Honor. I have two before you on your docket. The first one is real-time resolutions versus Joe Neubauer. It's 2017-8423.
Okay, yep, that's number 4. Okay, what's the status?
The status in that case, Your Honor, is loss mitigation application has been provided. It was approved, and they were given options to respond by March 7th. So it was asked for 60 days for another CMC.
No, that's fine. 6 days CMC on number 4, Michelle.
And then the next matter I have, Your Honor, is it's a 2018-8864, the Sweet Pea Holdings versus Emergency Cash Company. Counsel for 2 of the defendants asked that you call him. Would that be possible?
Sure, I need a phone number.
Sure, I can provide it to you, Your Honor.
Yeah.
It's 561-329-3477.
3477. Okay, let's give it a phone.
And we have an agreement, just, you want to
Let me just get him in line. Not a problem. So what's the status of the case?
The status of this case, Your Honor, this is a quite unique situation. There's federal forfeiture proceedings in this case that are happening in Virginia. The defendant's counsel made a motion to dismiss for lack of subject matter jurisdiction here. However, in the Eastern District of Virginia case, they're working on settling that globally.
Right.
So we asked for 60 days to allow that to happen. We think probably by the end of the month, they're going to figure out whether the USA is going to sell it or what's going to happen with the property.
That seems fair. So that one I'll go ahead and do. I'll do a 60-day CMC on that one.
Thank you, Your Honor. I'll fill out those orders.
Okay, perfect. Have a great day.
You too.
All right. Good morning, counsel. What
Good
case you
morning,
got?
Your Honor. I have 3 of them. They're all on your docket. The first one is HSBC Bank versus Young.
Okay, yeah, let me just find it. Hold on just a second.
Yes, Your Honor.
Yes, here, HSBC. Yeah, that's number 40. What's the status of this one?
Your Honor, this one was filed in September of 2018. I've spoken with the opposing counsel. He has an outstanding motion to dismiss. He's agreed to have that denied with 30 days to file a response.
Perfect. Let's do that in order.
What I said is,
Oh, sorry.
I'm going to file a counterclaim, so 30 days to file a counterclaim.
Pending for how long has the motion to dismiss been pending? Since September?
No,
So.
the case was filed in September.
Oh, okay. When was the motion dismissed filed?
It was just recently.
The motion to dismiss was filed
It was just recently.
on January 9th.
Oh, okay, that's fine then. All right, so let's not do 30 days to file the counterclaim. Let's do 20 days to file the counterclaim from today's date. Okay, so the motion dismissed, we'll do denied 20 days to file the counterclaim, and then you can answer the counterclaim. I'll do, on this one, I will go ahead and do a 60-day CMC, and then we'll get the pleadings closed and get you guys set for trial.
Great, thank you, Your
You guys
Honor.
have a great day. Nice seeing you guys.
Your Honor, the next one that I have is Rosario, Bank of New York Mellon versus Rosario.
Hold on a second, let me just find it on the list here. Okay, Rosario. Yeah, number 20, oh, sorry. Yeah, that one there, was that Deutsche Bank or Bank of America?
It is
What's the case
Bank of New York
number?
Mellon. It's 2018-015837.
That's a different one, okay. Oh, here it is, that's number 35. Yeah, what's this, oh, wait. 15837.
Yes, Your Honor.
Oh, yeah, here it is, that's 35, yeah. What's the status of that one?
This one was filed in December of 2018. We've spoken with the opposing counsel. She has a motion for extension of time. She just wants 20 days to file an answer on her file a response. I'm fine with that.
So I'm going to grant your motion for extension of time, 20 days to file the answer. Thank you. Perfect, thank you, just put that in order.
And then the final one that I have, Your Honor, is Baney, B-A-N-E-Y.
Okay, let me find that one on the list. See, that's number 26. What's the status of that one?
This one, there's a motion to dismiss that's pending. There's also discovery pending. Each side wants 30 days to respond.
30 days on a motion to dismiss. Set that motion to dismiss for UMC.
I think the motion was going to be denied, and
Right, we just need the 30 days for discovery.
Oh, that's fine then. Okay, no problem. So do the
30
order
days to
motion.
answer, 30
Motion
days.
dismiss is denied. Let's put that in the order. 30 days for each side to file their respective discovery.
Your Honor, I believe I might be misrepresenting something and mixing up the cases. I don't think they had a motion to dismiss. I think they had a motion for extension of time. They just want 30 days to answer, and then we have 30 days to
No
file a
problem.
response.
So put that in there. 30 days to file the answer, 30 days to do the discovery, and on that one, we will go ahead and do a 90-day CMC.
90 days CMC on that one.
Thanks for getting my heart going.
Okay, thank you. I know, we fixed it, but not a problem. All right, good morning. What case you
Good
have?
morning, Judge. Bank of New York, mailing notice of Applebound,
Applebound. Hold on, let me just find it on the list here. That's number 32. Okay, what's the status?
2018 case, Judge. You just entered an agreed order on the motion for extension of time. They have until March 14th, so it's still pending. Also, fortunately, there is pending loss mitigation.
So that one we'll do 90 days CMC.
Okay.
Perfect, thank you so much. That's
Thank you,
number 32. All right, thank you so much. All right, good morning. What case you have?
Bank of America versus Rashad Butler.
Butler, hold on just a second, let me find that one. And that's number 20. What's the status of that one?
This one, actually, we have to do a default on one of the defendants, and it's Gus Mitchell, one of the main party passed away.
Okay, that's fine then. So on that one, let's do a 60-day CMC.
Thank you.
All right, good morning. What case you have?
Morning, Your Honor. This is JP Morgan Chase versus 4040 Ibis and Rasabi.
Okay, that's Bobby. Yeah, that's number, that's my 2009 case. Yes, all right.
Race Harvey
My
here.
only but goodie. What's the status of this one?
Good morning, Judge T.W. Anderson from Gray Robinson for the plaintiffs. We have reached an agreement to settle the case with Mr. Rasabi, the individual defendant.
Great.
We're still dealing with the corporate defendant who's still in the ABC in Broward.
Okay.
We are
I
trying
was
to
hoping
work.
that'd be over by now. Okay.
We're trying to work something out with the assignee to get rid of the proceeding and to try to take care of that, but I think we need about 60 more days to do that.
Is that okay, 60 days then?
We're going to be out.
You guys are going to be out.
Yeah.
So at least we're making some progress on it.
Correct.
After 8 years. So that's fine then. So 10 years. So that's fine then. So on that one, let's go ahead and do a 60-day CMC then.
Thank you, Judge.
Thank you guys. Have a great day.
You too.
All right, Michelle, progress. All right, okay, what case?
Good morning, Your Honor. I have 6 of them.
Sure.
The first one, if we want to do Judge Curley's one first.
Yeah, what's the case?
It's Wells Fargo Bank versus Steve Cohen.
Yep, I have it right here. That is your motion to withdraw, right?
Yes, Your Honor.
All right, any opposition?
I don't believe so.
No opposition? Okay, all right, I'm gonna go ahead and grant the motion to withdraw. That one's fine.
Thank you, Your Honor. If I may approach with orders.
Sure, just hand everything to Bill. All right.
The next one, Counsel Taylor.
Yeah, oh, right.
It's on your calendar, Deutsche Bank versus Cheryl Perra-Louis. It's a motion to cancel the sale set for today. I apologize for that we bring it forward on today. There's been 0 cancellations previously. The defendant had applied for loss mitigation, however, was denied. It was denied on January 29th. We sent them a denial letter. However, the denial letter provides a 30-day appeal time. So we're asking that the sale today be canceled and to give the defendant an opportunity to appeal our denial.
Appeal the denial of what?
I believe they applied for a modification.
You're gonna appeal, appeal what, to the 4TCA?
No,
internally.
Oh, internally, oh.
Internally, because we said no to
Oh, okay.
their
So
loss
you're
mitigation
gonna try to do
request.
another loss made, is that what you're gonna do? Okay, that's fine, then, that's no problem. So on that one, so I'm gonna go ahead and cancel the sale. Do you want another sale date or not?
Yes, Judge, if you set out 60 days, I think that'll
Okay,
be
so another sale date, Michelle, 60 days, let's put that in the order. And then hopefully you guys, do you think maybe a formal mediation will be helpful, or you guys just wanna do it informally?
Informally.
Okay, that's fine then, so why don't you guys see if you can resolve it, maybe they can get approved for loss mit, and then we'll do another sale date for you guys within 60 days, just put that in the order.
Thank you, Your Honor.
All right, what's the next case?
The next one are all CMCs, Your Honor. The first one is, and I'll do them in this numerical order.
Sure.
2017 CA 008995 Wells Fargo versus Camilla Gordon.
Gordon, got it.
Judge, we are at issue and ready for trial.
Okay, how much time for the trial?
We asked for an hour, Your Honor.
Okay, 1 hour for trial, the trial will be set within 60 days.
Thank you, Your Honor.
All right, thank you guys on that one.
Thank you, Your Honor. The next one is 2018 CA 008111, and that is Ditech versus Gallo Lograno.
Yep, that's number 33. All right, what's the status of that?
Judge, in that one, the case is not at issue. We are pending defaults. We send in defaults to the clerk. Pending that, we should be at issue, and we can notice it for trial.
That's fine. I will do that then. On that one, let's do a 60-day CMC.
Thank you, Your Honor.
All right, thank you so much.
The next one is 2018 CA 010760 Bayview versus John Walk. And on that one, Your Honor, the...
Good morning, Your Honor. Number 17, okay. Great, yes. What's the status of this one?
Good, I'm sorry.
I'm sorry, Judge, we are not at issue. With the plaintiff, we had filed a motion to strike the defendant's affirming defenses, which still has not been heard.
Your Honor, this case actually has been consolidated with the quiet title action that had been pending before Judge French.
Okay, that's fine. Well,
With
can't
Your Honor,
consolidate, it needs to be the other division.
actually, you have the older case, Your Honor. They haven't answered the quiet title complaint either.
okay, that's fine.
And I had contacted them on Friday, and I got motions directed to my answer yesterday rather than the answer to the
So
quiet
that's
title
fine then. So why don't you move that case over to this division? We'll consolidate both, and on this one, I'll do another case management 90 days, and then hopefully.
There's already order of
Oh, you're done.
consolidation.
Excellent, okay. That's fine then. So, and then what we'll do then is, let me do on this one a 90-day CMC then.
Thank you, Your Honor.
Sounds good, Your Honor.
Have a
Thank
good
you.
day.
And then Judge, finally, the last one I have is 2018 CA 014077 Wells Fargo versus Peter Harold.
Harold, let me find that one. Yeah, number 13, yeah.
Judge, I believe there's one remaining issue between us. It's the reformation count, but I believe counsel, the defendant has, we're in the middle of a settlement, or they.
Probably already been sold. It's already been in closing based on the.
So why are we here? Why is the case still open?
But I'm just waiting for my dismissal from my client, and then just to figure out the reformation, because I think there might be one small issue, but other than that, I think we can have this resolved within the next 30 days.
Okay, so on this one, let's do 45 days CMC.
Thank you, Your
All
Honor.
right, thank you guys. Have a great day.
Thank you.
All right, good morning. What case you
Good morning, Your Honor. Centrust v. Larson, 2018 CA 0.
Yeah, number 10. Yeah, what's the status of this one?
There's still a pending motion for extension of time.
Okay, I'll grant that. How much time do you need?
20 days would be great.
20 days is okay. That's fine. And on that one, we'll do a.
Actually, sorry, may I?
Yeah.
I think a little extra time. The issue is transferring ownership. It's a mother with 3 sons. The mother and one of the sons passed away.
Okay.
So the 2 sons remaining, with one son has power of attorney over the other and is trying to transfer
Okay.
ownership.
Do you want 30? Is that better?
That would be much better.
Let's do
Thank
30
you.
days. I'll make a motion for extension of time, and let's do a 60-day CMC on this one.
Thank you, Your Honor.
Thank you, guys.
Thank you, Your Honor.
All right. What's the case?
Your Honor, I apologize, there was one item that I forgot on the uncontested case, Wilmington versus Vicario Romero. There was a pending judicial default against the unknown spouse, which you had previously agreed. I
Yes.
just want to make sure that I can
Put that
add
in
on
the-
the
yep.
CMC. Okay.
Exactly, that's fine. All right, good morning, counsel. What case you have?
Good morning, Your Honor. Kurt Phillipson versus Edison Insurance Company.
Sure. Is that my case or Judge Curtis?
Your case.
Okay, great.
We were here about 3 weeks ago asking for a continuance on the trial. We just had mediation on Thursday. We got a trial order, but the trial set for March 4th.
Oh, I don't know, that must have been my error. We'll fix it, not a problem. When do you guys want the trial?
Okay, we still haven't conducted discovery. The mediation was not successful. We still have some discovery to conduct.
I'll set it whenever you guys want to. What month? Do you think April, May, June? When do you think would be good?
June, if possible.
June? Is it okay? June? Okay, we'll set it for trial the first week of June.
Perfect.
All right, did you see the case number then?
It's 2018 CA 000870.
So just fill out an order motion for continuance is granted. Shall be set for trial the first week of June.
Perfect. Thank you, Your Honor.
Thank you so much. Have a great day. All right, good morning.
Bill Lincoln, Your Honor, here for New Balance, real time. The case was heard, the Essex Council just ran away, I guess. He didn't want to wait, so
Yeah.
I just want to make my appearance.
Not a problem.
You've
Good to
entered
see
an
you.
order, you've entered an order and set.
The order's fine. Okay, perfect. Have a great day.
Thank you.
All right, good morning. What case you have?
Good morning, Your Honor. For Judge Curley, Federal National versus Christopher Granitz, it's an agreed motion to cancel and reset the sale date.
That's fine. I'll be happy to do that. When do you want the sale date?
Let me see here. It's an approved short sale. I think 45 to 60, I guess 60 to be safe.
It's fine. Michelle, I'll give you 45 days sale date.
45.
45 days. Oh, no, 60. 60 days sale date. Judge Curley's case.
Thank you.
Perfect. Thank you so much. I'm going to call out the rest of the motions here, and then I'll call out the rest of the CMCs as well. Then, let me just make sure. Some of them I may have already done. Wells Fargo Cone, we already did. Let's see. Fisher Fabricant, we already did. Hockenberry Torque.
President Council's in another courtroom.
Okay, well, they need to be here by 9:30 because they're going to miss their meeting. So, okay. Taglione Stroh versus Zandall Fireworks. Motion dismissed. Taglione Stroh, anyone here on this one? No one's here on that one? Okay. All right, let me go ahead and do Phillipson versus Edison Insurance. Motion to extend trial deadlines? No?
Your Honor, that's the case we just.
Oh, we just did that one, that's the one we just did, okay, I'm so sorry, thank you. Okay, I didn't have the notice here on that one. All right, Garofalo versus Sadeo. Motion to compel interlocutors, I think we did that one already, yep, we did. Okay, Deutsche Bank versus Pierre Lewis, we already did that one as well. Huluth versus Riley. Councilor Dan, both sides here? Yes. All right, come on.
Morning, Your Honor. Gabriel Dobrin for Mr. Mellinger. This is my motion.
Yep, I read your motion. And this is a motion for more definite statement, and I read your motion. You may proceed when you're ready, counsel.
Thank you, Your Honor. This case involves 3 separate accidents. My client is the last one in the queue. It's a parking lot accident. The issue we have with the complaint is that it lacks any factual allegation. The only allegations are in 19 and 45 of the complaint. They're simply conclusory. It has no facts to support the cause of action for negligence. We would like more allegation of facts to see what they're saying, what my client did wrong. And I also have a motion to enlarge the time for discovery.
But let me ask you, what elements of the cause of action are missing for negligence?
No fact, Your Honor.
Then I can't, then that's what discovery's for, right?
No, Your Honor. The case law is very clear. In order to support a cause of action for negligence or any cause of action, you have to include some factual
But they said there was duty, breach, causation, damages. What else do they need?
The facts, Your Honor. What did my client do wrong? They're only saying that he operated...
Caused an accident. He operated the vehicle negligently.
Right, but they're not putting any facts.
You don't have to. It's duty, breach, causation, damages.
Your Honor, the case law that I cited is specific. You have to include some factual allegations.
Your Honor, I completely agree with you. Obviously, I'm looking even at Form 1.945.
The Supreme Court form.
And it literally, we cited it word for word.
The Supreme Court form.
And like you said, that's what discovery is for.
In most cases, that would be enough. But in this case, there's actually a witness that is totally contradicting the plaintiff.
Then that's fine. Then you take the witness's deposition, you file a motion for summary judgment. I'll decide on a summary judgment, or you present that witness in trial. Motion to more definite statements denied. How much time do you need to answer the complaint?
15 days, Your Honor.
15 days?
I'm fine with that, Your Honor. As to the discovery, could I have 15 days too? We've been waiting for 4 months.
15
Yes, 15 days.
15 days on the discovery.
15 days for discovery and to respond or answer the complaint.
Answer.
Thank you, Your Honor.
Thank you guys. Have a great day.
You too.
All right. Let me go ahead and please do Deutsche Bank Pierre Lewis. I think we did that one already.
Yes, Your Honor.
Okay, let me just see. Federal National Grants. Motion to cancel reset. We did that one already. Huluth versus Riley. Must have done that one already. Okay, let me call the rest of the CMCs and see if there's anybody else here on any other CMCs. Anyone here on cash? I'm going to go through the shop. Number 1, Cash Now Capital Partners versus PE. 2018-14431.
Good morning, Judge. I'm here for the defendant counsel.
Okay, plaintiff's not here?
Apparently not.
Case dismissed.
Thank you, Judge. Yes, ma'am.
Okay. Alrighty, let's see. Number 21, U.S. Bank DuPont. Okay, that one's dismissed. 22, Wells Fargo Dozen. That one's dismissed. Okay. Nation Star Pop. Same thing. And Wilmington Howler. 2015-11433. Okay, those are all taken care of. All right, let me call out some more UMCs. Otherwise, we need to find out where the opposing counsel is in these cases. Hockenberry Toric, anybody here?
I'm here.
I'm going to be cutting off at 9:30. What courtroom are they stuck in? I've done 50 hearings, which are already.
I know,
So
I don't know which court.
tell them Judge Sasser's done 50 hearings for 2 judges already. They need to get down here. Okay? All right. Huluth Riley. Nobody's here on Huluth Riley. Taglione Stroh versus Zembel Fireworks. Anybody else here for UMC or CMC other than the one we're waiting for opposing counsel on? No? Okay, all right, let me try to call the 8:30 Michelle. Okay. One more time.
trying to reach is not accepting calls at this time. Please try your call again later.
Yes.
Stupid question. Do you e-serve?
Yeah, we do, we start with e-service.
E-serve, so I just have to give you
Just
one?
one.
Okay.
Everything, electronic.
Then approach?
Yeah, just hand it to Michelle.
Thank you.
You guys have a good day.
Is the dismissal with prejudice or?
Dismissal, yeah, with prejudice. All right, thank you, have a great day. All right, Mark, let me know when they're ready on the other, last hearing then. So, if they're here, and that's it. All right, thank you guys, have a good day. Any order?
Someone checked in.
They called it already.
Let me see, you have an order there for it, that you. They called us up a while ago.
Yeah, I know, it's not that close again.
It ends in 4664.
Do you have the notice of hearing for the Hockenberry?
Number 2.
Do you have the notice of hearing for the Hockenberry? I know I did see you say, 90 days. Can you look
He has to come back in 90 days?
Yeah, transfer it to somebody that can help me look up the phone number.
What's the date, you know? He's not gonna know, he's not a...
Okay, it will be emailed tomorrow.
Okay. They're gonna reset this for 90 days from now, you get an email.
Anyway, I never received this. My friend put this thing off the internet, and I never got a copy of this at my house.
You
So
have
I
the
wouldn't
correct-
even know I have this until
You have the
yesterday.
correct address?
Yeah, but my address is 1038 Southwest Video Terrace. And this is a 1720 South Military Trail.
Do you want to write it down there? Do you have an email?
No.
Okay, why don't you write the correct address on here and I'll keep this over. Right here. Understand right there. Yeah, she called that early on.
When I get this paper yesterday from my friend, I called them out, and they had no.
I'm here.
You were here earlier.
Yes, I was.
That had a hearing.
All right, no problem, just gonna fill it out, give it to the judge.
I couldn't remember what courtroom we were in because I was different. So you know what? I almost, as soon as I got back in there, I said, crap, I should have given her my cell phone number. Yeah, I was trying to call and figure out. Yeah.
Court's back in session.
All right, you guys ready?
Yeah, I'm so sorry, Your Honor. I was running back and forth between your courtroom and Judge Coach's room, so I appreciate you taking us.
No problem. All right, let's proceed then. This is Hockenberry versus Court.
Yes, Your Honor.
And this is the motion, which I went ahead and read. This is plaintiff's objections to defendant's supplemental request, and you may proceed when you're ready, counsel.
Your Honor, essentially, we propounded these, or we sent these authorizations. They're essentially the same thing as subpoenas. They request the same amount of information as subpoenas. The regular subpoenas that we send out say, send us a copy of your entire file.
Sure.
This is exactly what the authorization is doing. This is routine practice in federal court. They still have the ability to object to this, just like they have the ability to object to a subpoena. They have the ability to ask for copies, just like they have the ability to ask for copies for a subpoena. And there's nothing, no law, no rule, no case law that says we can't send these.
What's the basis of the objections?
Your Honor, based off, I referenced two cases in this matter. The first one is Renhart versus Northside, which is a fourth DCA case. And it basically states that the Florida Rule of Civil Procedure 1.351, notice of non-party from third parties, is the route that you take. If there's a showing that this is unsuccessful, then they can request medical authorizations. And if it was outside providers, we are okay with doing the medical authorizations, but these are all Florida, and they haven't, we don't have a showing that they even attempted to do any subpoenas.
But what did they do procedurally incorrectly?
First, you have to do a notice of non-party production and do the subpoenas. If they
Why do they have to do that first?
Based on the case law, that is
I'm not
what...
familiar with that case law. Can I see that case law?
Yeah.
They have to do that first? Can you show counsel first?
I have a copy of it.
Yeah, I sent a copy last week. There's two different
They
cases.
have to do that first? That's for sure.
Yes, that's what the case law indicated. There's one from the 4th DCA and a Supreme Court ruling of Florida, which in that case it was outside providers, but before they requested medical authorization forms, they did attempt to subpoena the medical records.
Oh, okay, okay. That's fine then. So response?
Your Honor, it's my understanding that this is regarding some California records, just based on my brief review of this. Again, I don't see the holding of this case is that we are required to send subpoenas prior to medical authorizations, unless I'm missing it.
Yeah, this doesn't say that here.
Right.
Where does it say that?
It states in, this is a request where they requested medical authorizations. And
Well, the Rojas case talks about out of state, so that one's different.
right, but
So-
the difference between the Rojas state is basically that in that case, they did attempt to do the appropriate route, which is the subpoenas before requesting medical authorizations. The Renhart case basically states that, and it's in the last paragraph.
No, but the cert was granted because this is a cert petition. The cert was granted because the trial court ordered it without giving them time to do the medical authorization, it looks like.
They ordered it because they did not do subpoenas. They said Florida Rule Civil Procedure 1.351 provides for production of documents from a person who is not a party by issuance of a subpoena, directing production of the documents or things when the requesting party does not seek to depose the custodian or other person in possession of the documents. Respondents made no attempt to obtain the records through the existing means of discovery.
But here, this isn't existing means of discovery. This is normal, right?
And it states further, in the absence of showing that the records cannot be obtained
That's not
by the
required.
use.
Why do they have to show that? This happens in every auto negligence case, right?
I mean, we've been doing it relatively routinely, Your Honor. Again, if there was some prejudice to counsel that she could point out, I would
You
understand.
can always file an objection.
And we did file an objection.
The
This was our
objections are
objection.
rules. I don't think they have to do step by step by step.
Okay, that's what this case law states in the 4th DCA and the Supreme Court.
If there's an objection to a specific provider, then certainly they can file that objection and say, we don't, for example, we don't want you to subpoena employment records because there's no wage loss claim. Understandable.
Usually they're done at the same time. I mean, usually.
I've never had, anytime this has been brought up, we tell them we do this objection and they say, okay, we'll attempt to do the subpoenas. And if they have an issue with doing a third-party subpoena, which is from non-parties.
Usually they do both though, right?
No, not when I do it. It's if they do not get the records and they have, for example, hospitals. Some of them object saying they need a medical authorization. Once we get that paperwork saying that they could not obtain the records, we then provide a medical authorization. Here, there's no showing that they even attempted to do a notice of no non-party production, which is pursuant to the rule, without our client signing a medical authorization. They're not going through the appropriate measures in the rule.
But why can't they require a client to sign a medical authorization? What's the matter with that?
I'm telling you what the case law states, and that's what it states.
I have never heard this objection ever before, ever. So, I mean, what's the legal, okay, do the first party then, if that's what this case says, then that's fine then. All right, do this, I'll sustain the objection, do this, and then, but I'm gonna shorten the time. So,
Thank you, Your Honor.
let's shorten the time for medical providers, 10 days.
And
So-
can we do the certificate of not shorten that time period as well, instead of 15 days, do 5 days?
5 days, yeah,
Thank
so
you.
it's gonna be the same thing anyway.
Okay.
So we're just.
Well, I haven't even seen the subpoena language.
Well, if that's what the objection was about, then that's what we should be here on. So.
They haven't done any subpoenas. They just strictly did a notice of
I
non-party
know,
production.
they can
to
do the
provide-
subpoena, but I'm gonna shorten the time to do the subpoena. So it's gonna be 10 days.
So we have to file an objection within 5 days because that's what
Yes.
she just requested?
Yes. Okay, all right, thank you, but that complies with the case law.
Thank you, Your Honor.
All right, thank you guys. Have a great day, everyone.